Florida Statutes Section 733.6171, Compensation of Attorney for the Personal Representative. Except as provided in paragraph 2D, attorneys for personal representatives are entitled to reasonable compensation payable from the estate assets without court order. The attorney, the personal representative, and persons bearing the impact of the compensation may agree to compensation determined in a different manner than provided in this section. Compensation may also be determined in a different manner than provided in this section if the manner is disclosed to the parties bearing the impact of the compensation and if no objection is made as provided for in the Florida probate rules. An attorney representing a personal representative in an estate administration who intends to charge a fee based upon the schedule set forth in subsection 3 shall make the following disclosures in writing to the personal representative. There is not a mandatory statutory attorney fee for estate administration. The attorney fee is not required to be based on the size of the estate, and the presumed reasonable fee provided in subsection 3 may not be appropriate in all estate administrations. The fee is subject to negotiation between the personal representative and the attorney. The selection of the attorney is made at the discretion of the personal representative, who is not required to select the attorney who prepared the will. The personal representative shall be entitled to a summary of ordinary and extraordinary services rendered for the fees agreed upon at the conclusion of the representation. The summary shall be provided by counsel and shall consist of the total hours devoted to the representation or a detailed summary of the services performed during the representation. The attorney shall obtain the personal representative's timely signature acknowledging the disclosures. If the attorney does not make the disclosures required by this section, the attorney may not be paid for legal services without prior court approval of the fees or the written consent of all interested parties. Subject to subsection 2, compensation for ordinary services of attorneys in a formal estate administration is presumed to be reasonable if based on the compensable value of the estate, which is the inventory value of the probate estate assets and the income earned by the estate during the administration as provided in the following schedule. $1,500 for estates having a value of $40,000 or less. An additional $750 for estates having a value of more than $40,000 and not exceeding $70,000. An additional $750 for estates having a value of more than $70,000 and not exceeding $100,000. For estates having a value in excess of $100,000 at the rate of 3% on the next $900,000. At the rate of 2.5% for all above $1 million and not exceeding $3 million. At the rate of 2% for all above $3 million and not exceeding $5 million. At the rate of 1.5% for all above $5 million and not exceeding $10 million. At the rate of 1% for all above $10 million. Subject to subsection 2, in addition to fees for ordinary services, the attorney for the personal representative shall be allowed further reasonable compensation for any extraordinary service. What is an extraordinary service may vary depending on many factors, including the size and complexity of the estate. Extraordinary services may include, but are not limited to, involvement in a will contest, will construction, a proceeding for determination of beneficiaries, a contested claim, elective share proceeding, apportionment of estate taxes, or any adversarial proceeding or litigation by or against the estate. Representation of the personal representative in audit or any proceeding for adjustment, determination, or collection of any taxes. Tax advice on post-mortem tax planning, including but not limited to disclaimer, renunciation of fiduciary commission, alternate valuation date, allocation of administrative expenses between tax returns, the Q-tip or reverse Q-tip election, allocation of GST exemption, qualification for Internal Revenue Code sections 6166 and 303 privileges, deduction of last illness expenses, fiscal year planning, distribution planning, asset basis considerations, handling income or deductions in respect of a decedent, valuation discounts, special use and other valuation, handling employee benefit or retirement proceeds, prompt assessment request, or request for a release of personal liability for payment of tax, review of estate tax return in preparation or review of other tax returns required to be filed by the personal representative, preparation of the estate's federal estate tax return, If this return is prepared by the attorney, a fee of 0.5% up to a value of $10 million and 1/4% on the value in excess of $10 million of the gross estate, as finally determined for federal estate tax purposes, is presumed to be reasonable compensation for the attorney for this service. These fees shall include services for a routine audit of the return, not beyond the examining agent level, if required. Purchase, sale, lease, or encumbrance of real property by the personal representative, or involvement in zoning, land use, environmental, or other similar matters. Legal advice regarding carrying on of the decedent's business or conducting other commercial activity by the personal representative. Legal advice regarding claims for damage to the environment or related procedures. Legal advice regarding homestead status of real property or proceedings involving that status and services related to protected homestead. Involvement in fiduciary, employee, or attorney compensation disputes. Proceedings involving ancillary administration of assets not subject to administration in this state. Upon petition of any interested person, the court may increase or decrease the compensation for ordinary services of the attorney or award compensation for extraordinary services if the facts and circumstances of the particular administration warrant. In determining reasonable compensation, the court shall consider all of the following factors, giving weight to each as it determines to be appropriate: the promptness, efficiency, and skill with which the administration was handled by the attorney, the responsibilities assumed by and the potential liabilities of the attorney, the nature and value of the assets that are affected by the decedent's death, the benefits or detriments resulting to the estate or interested persons from the attorney's services, the complexity or simplicity of the administration and the novelty of issues presented, the attorney's participation in tax planning for the estate and the estate's beneficiaries, and tax return preparation, review, or approval, the nature of the probate, non-probate, and exempt assets, the expenses of administration, the liabilities of the decedent, and the compensation paid to other professionals and fiduciaries. Any delay in payment of the compensation after the services were furnished, any agreement relating to the attorney's compensation, and whether written disclosures were made to the personal representative in a timely manner under the circumstances pursuant to subsection 2. Any other relevant factors. If a separate written agreement regarding compensation exists between the attorney and the decedent, the attorney shall furnish a copy of the personal representative prior to commencement of employment and, if employed, shall promptly file and serve a copy on all interested persons. A separate agreement or a provision in the will suggesting or directing that the personal representative retain a specific attorney does not obligate the personal representative to employ the attorney or obligate the attorney to accept the representation. But if the attorney who is a party to the agreement or who drafted the will is employed, the compensation paid shall not exceed the compensation provided in the agreement or in the will. If you're interested in any of our services, please call 321-206-3603 or visit easlerlaw.com to book a consultation.